Do you believe that voter ID is inappropriate?
My commitment is to uphold the Supreme Court's decision in Crawford v. Marion
I know, but
County.
here you said it was inappropriate. You deny that? You deny that you said it?
I can't say that I haven't seen that language in front of me, but what I do know is that there have been voter ID cases in which courts have found
I'm just asking you to explain to me why having to prove you are who you say you are before you vote doesn't serve, you said it doesn't serve any legitimate state interest. I'm just asking you to explain that statement to me.
The cornerstone of any functioning democracy is the integrity of the ballot. Yet a fundamental disagreement persists over the most basic security measure, proving one's identity. When a judicial nominee struggles to explain their past opposition to voter identification laws, it raises significant questions about their fitness for a lifetime appointment. The exchange between Senator John Kennedy and Nancy Abbott serves as a critical case study.
Report from the Southern Poverty Law Center about voting in Louisiana. Did you say, quote, racist white Southerners, close quote, and quote, hostile white voters and governmental officials in Louisiana continue to make local polling places and early voting locations threatening spaces for black voters? Did you say that?
Senator, I do not believe that I said that. I haven't read that publication in some time.
Will you help write it?
I helped to draft the publication and approved it, but I'm not familiar with that language.
You don't? Okay. In that same report, did you say, well, tell me where in Louisiana local polling places and early voting locations are threatening African-American voters? You said it, so which polling places?
So again, Senator, obviously I don't have that report in front of me to be able to read and remind myself of the examples that might have been shared. But what I can say is that Louisiana...
Let me cut you off because I'm going to run out of time, Counselor. Let me ask you one more. In August 2021, we're not talking 20 years ago, we're talking 2021, you were involved in another report by the SPLC. And you said that voter identification, photo ID to vote, is burdensome and does not serve any legitimate state interest. Do you really believe that?
Senator, identification for voting is something...
Yes, but first, do you really believe that? You said it. You meant it?
The Supreme Court in Crawford v. Marion County has already upheld voter ID laws as per se constitutional.
Yeah, but you said it didn't serve any legitimate state interest. Do you believe that?
Again, Senator, without that language in front of me, it's hard to understand the context.
You said it. Here it is, August 2021.
Well, there are cases...
I'm just asking you to explain to me why having to prove you are who you say you are before you vote doesn't serve, you said it doesn't serve any legitimate state interest. I'm just asking you to explain that statement to me.
I understand, Senator Kennedy, and again, without being able to see the language that appears before and after, it's hard for the context.
Do you deny that you said it?
I can't say that I haven't seen that language in front of me, but what I do know is that there have been voter ID cases in which courts have found
I know I'm familiar with the case law, but I'm asking what you think, because you may be on the 11th Circuit. Do you believe that voter ID is inappropriate?
My commitment is to uphold the Supreme Court's decision in Crawford v. Marion County.
I know, but here you said it was inappropriate. You deny that?
Well, again, Senator, it would be helpful to know if that section of the report also cites to cases in which federal courts have found that certain voter ID laws do pose an burden on voters.
At the heart of the controversy is a 2021 report from the Southern Poverty Law Center, a document the nominee helped draft and approve. This report allegedly characterized voter ID requirements as burdensome and lacking any legitimate state interest. This position is not merely a matter of policy preference. It represents a direct challenge to established legal precedents that recognize the state's role in securing elections. When pressed to explain why verifying a voter's identity does not serve a legitimate purpose, the nominee repeatedly retreated into the perceived safety of context. Despite having helped author the publication in question, she claimed an inability to recall the specific language or the examples cited within it. This lack of clarity is troubling for an individual seeking to serve on the federal bench, where precision is a requirement. The refusal to stand by past statements or provide a reasoned defense of them suggests a disconnect between personal advocacy and judicial duty. Senator Kennedy highlighted a clear contradiction. The Supreme Court has already upheld voter ID laws as constitutional. For a potential judge to suggest these laws serve no purpose ignores the reality that identifying voters is the primary method for preventing fraud and error. Furthermore, the report in question reportedly used highly charged language, describing certain regions and voters as inherently hostile or threatening. When asked to provide specific evidence or locations where these conditions exist today, the nominee offered no concrete data. This reliance on generalized narratives over specific facts is the antithesis of what is expected from a member of the judiciary. The broader implication of this exchange involves the standards we set for those who interpret our laws. A judge must be able to articulate their reasoning clearly and base their decisions on the Constitution, rather than ideological reports. If a nominee cannot explain why they once dismissed the state's interest in election security, the public is left to wonder how they might rule from the bench on future voting rights cases. Skepticism toward political power is a healthy trait in a republic, but that skepticism must be applied to the judicial selection process as well. We must ask whether we are appointing individuals who prioritize the law or those who use the law to advance a specific worldview. The ability to defend one's intellectual record is a minimum threshold for holding a position of such immense public trust and institutional authority. Election integrity should not be a partisan issue, as it is the foundation upon which all other civil liberties rest. Ensuring that every legal vote counts requires a transparent system that remains above reproach. When judicial nominees evade questions on these essential protections, it erodes confidence in the legal system and the very concept of the rule of law. Ultimately, reason dictates that a state has not only a right, but a duty to ensure that its elections are secure and that every participant is who they claim to be. A refusal to acknowledge this basic principle suggests a philosophy that may be at odds with the constitutional framework of the United States. True judicial independence requires a commitment to fact, precedent, and the impartial application of the law.